Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I hope you guys are having an amazing day. Let's talk about Miss Tasha K. I've been looking around and stumbled upon a lawsuit that I don't think people know about. I tried to Google it and noticed that it does not pull up when you do a actual Google search as far as like uh, Tasha K lawsuits. It just shows the main ones against, well, not against the lawsuits that Soldier Boy has filed, Kevin Hart, and obviously Cardi B. So I had to go into my personal program that I use and do a case search, and I stumbled across it, and I was like, okay, I gotta spill the court tea. So let's hop right on into it. So, as you can see, hopefully you guys can see that this case was filed in Miami-Dade. It's Omar Graham versus Tasha K and other individuals and entities. It was actually filed on August 6th, 2024. Um, so it's fairly new. It is in the beginning stage. The type of case, as you can see, is in the negligent security case. I briefly reviewed the petition or the complaint that was filed, and it's going to be pretty entertaining. So the parties is a total of seven parties. Obviously, the plaintiff, Mr. Omar Graham, who it is, I have no clue, but he is being represented by an attorney. The defendants is Tasha K, uh, Chikna Kibi, I'm assuming that is her husband, Sony Ventures LLC, Goldman Development LLC. They are being represented by an attorney, not Tasha K or her husband, but Sony Ventures and Goldman Development. And then we have Stunta, and then obviously we know that Latasha Kibi is Tasha K, so they have her alias down there. As of right now, no hearings has been set because, like I said, we're still in the beginning stages of everything. So I'm going to start from the bottom. So as I stated, the petition was filed August 6th, and let's see, summons were sent out on November 25th. And as of right now, it shows that the husband, it was an e-summons that was issued, and let's see. And I believe to that's the e-summons for Goldman Development. So all of these summons were sent electronically by email. Okay, so it wasn't where they have to get a process server to go actually serve them. Now, if they don't receive any confirmation that the email has been viewed or accepted, then that's when they would have to move to get them served. But as of right now, looking at this on October 3rd, there was a notice of appearance filed by Sony Ventures, which means that obviously they did receive the summons. And then if we scroll up, another notice of appearance was filed on October 29th for Goldman Development. So that's why we see attorneys actually in the parties tab for those two entities. Now, as far as let's see, and then on the next day, Sony Ventures actually filed an amended notice of appearance. But as of right now, it does not show that Tasha K has even reviewed the email with the summons. I don't know what's going on because nothing has been filed or docketed showing that she was in receipt of the complaint and summons. Now it shows on the 4th of November, Slim Stunta. I'm assuming that they probably just got his email, and so they were able to e-serve him with the summons as well. So I'm going to keep up to date on this docket to see if Tasha K is going to respond. We know definitely that they were served via e-summons or electronically, but they haven't filed a response, which is weird. Like, come on, girl. You like, I'm pretty sure if your husband got that email, your husband gonna be like, oh girl, we got sued. Right? All right, so let's hop right on into the actual complaint. Let's do this. All right, so we already know what who the parties are, so I'm not going to go over that again. So here are the general allegations. So this action was brought for damages in excess of $50,000. Whenever it says this, it does not say that they're asking for $50,000. That is just the jurisdictional limits of this particular court. All right, so nothing less than $50,000 is going to be way more than that, and that all depends on, once again, the burden of proof is on the plaintiff or petitioner. So he has to show he has damages depending on what happened or what the incident was about. Let's see, it says that at all times, material herein, the plaintiff Omar Graham was and is a resident of Palm Beach County, Florida. That at all times, material herein, the defendant Sony Ventures, aka Freehold, aka Freehold Hospitality, aka Freehold Studios, is a New York LLC limited liability company filed under the same name, Sony Ventures LLC, with a Florida fictitious name filed and its principal place of business listed in Miami-Dade County, Florida. So, Goldman Development is a corporation that is licensed to do business in Florida. Then we have Slim Stunta. So, Slim Stunta was and is a natural person known by the assumed name Slim Stunta, and his legal name is currently unknown to Graham. On or about November 4th, 2023, Omar Graham was legally invited and attended a private influencer party located at the premises of, I'm just trying to make sure that as far as Tasha K's address, I don't want it to show up. He was invited to the premises owned and operated by defendant Goldman Development LLC and leased by defendant Sony Ventures LLC, also known as Freehold, Freehold Hospitality, and Freehold Studios, which is located at that premises. Let's see, the party was hosted by defendant Slim Stunta, who was present at the party. The party was also attended by defendants Tasha K and Chekna Kibi. I don't know how to say his first name, so I'm sorry if I am butchering that name. And it is assumed by the filing of this lawsuit, they were invited to the party as well. The defendants Tasha K and, I'm just going to say her husband, were accompanied by unnamed individuals as members of a private security detail and or entourage and or private party. While enjoying the party, plaintiff Omar Graham met defendant Tasha K. Upon meeting defendant Tasha K, plaintiff Omar Graham presented Tasha K with his business card and verbally complimented her body and appearance. Following this interaction with Tasha K, plaintiff Omar Graham proceeded alone to the bar to get a beverage. While getting a beverage at the bar, many minutes and sometimes after his verbal interaction with the defendant Tasha K, plaintiff Omar Graham was physically attacked by defendants Tasha K, her husband, and approximately 5 members of defendants Tasha K's entourage and or private security detail and or private party. During the attack, plaintiff Omar Graham was thrown to the floor by defendants Tasha K, her husband, and 5 members of defendant Tasha K's entourage and or private security detail and or private party, all whom punched, kicked, and stomped with high heel shoes. In addition, plaintiff Omar Graham was struck in the head with a bottle. During the attack, Tasha K stomped on plaintiff Omar Graham's face and head with her high-heeled shoe. The attack lasted for several minutes without the presence, aid, rescue, or assistance of premise or party security. Many of the material matters discussed herein were captured on film and published widely across social media platforms. Maybe I just missed it because I need to do some deeper research because I'm like, what? As a result of this attack, plaintiff Omar Graham suffered bodily injury resulting in pain and suffering, disability, disfigurement, scarring, mental anguish, emotional distress, reputation, loss of capacity for the enjoyment of life, embarrassment, expense of hospitalization and medical treatment, medical and nursing care and treatment, loss of earnings, and the loss of the ability to earn money both past, present, and future. That the losses are either permanent or continuing in nature, and that the plaintiff, Omar Graham, will suffer said losses in the future. Both jurisdiction and venue are proper because the entirety of the incident in question took place in Miami, Florida, and as such in Miami-Dade County, Florida. So, first count battery against Tasha K. So that at said time and place, Tasha K initially and in concert with defendant, her husband, and five members of defendant Tasha K's entourage and or private security detail and or private party touched and or struck plaintiff Omar Graham, including but not limited to punching, kicking, and or stomping plaintiff Omar Graham's face with high-heeled shoes. That at said time and place, defendants Tasha K intentionally and in concert with the other defendants, that's what I'm going to say, caused plaintiff Omar Graham bodily harm. Plaintiff Omar Graham did not consent to the attack, and that said attack occurred entirely against his will. As a direct result of this intentional attack, plaintiff Omar Graham suffered bodily injury resulting in pain and suffering, disability, disfigurement, scarring, mental anguish, emotional distress, reputation, loss of capacity of the enjoyment of life, embarrassment, expensive hospitalization, medical and nursing care and treatment, loss of earnings, and loss of the ability to earn money both past, present, and future. That the losses are either permanent or continuing in nature, and that the plaintiff Omar Graham will suffer his losses in the future. So this is why he is asking for a judgment against Tasha K of more than $50,000, punitive and treble damages to exceed more than $50,000, and any other further relief that this court deems just and proper. He also demands a jury trial. Mm-mm-mm. Count two, battery against the husband. Same, pretty much the same thing. Pretty much the same thing. Let me see. Okay, they just kind of repeated everything. So the same thing against Tasha K is the same thing that is against her husband. In addition, he's asking for a judgment against the husband in the damages in the amount more than $50,000, punitive and treble damages more in the excess of $50,000, and any other further relief that the court deems just and proper. So right there, that's over 200K. Negligence security. So this is count three against Slim Stunta, who's, that's his party. So he therefore is responsible for all the invitees that attended that party. And in addition to that, just like we saw in the Black China uh, complaint read, when you have a party, right? And it doesn't even have to be a party. It could be any place that we go to, any business. We are thinking that we are safe. Even in the Zeus lawsuit where the bodyguard assaulted a fan. The that person ended up suing Foot Locker. That's also negligent security because, like, where was the people that's supposed to keep the premises safe? So this is only right that they sue this person because all invitees should be safe no matter what. So plaintiff Omar Graham was an invitee of the premises and was present at the party in response to an invitation sent out via social media through the partner's promoter on behalf of defendant Slim Stunta. The premises was owned and operated by defendant Goldman. The party was hosted and the premises was subleased and possessed by defendant Slim Stunta. Defendant Slim, as a subleasee and possessor of the premises, negligently failed to adequately maintain the premises in a safe condition by failing to provide sufficient security detail for the party. Defendant Slim Stunta knew or should have known the attacks on party attendees were possible. This is standard language, but at the same time, it is a party, okay? Whether you feel like you have, an elite guest, um, you always have to think about safety. So that's why we put that language in there. Um, Slim should have known sufficient security detail was necessary to protect the party attendees from attacks and to prevent such attacks. Defendant Slim was the legal and proximate cause of plaintiff Omar's attack, which occurred without assistance, rescue, and or aid of security. I'm sorry, I'm up here checking my email. Okay. Let's see. Now we have this, I'm sorry, that as a direct and proximate result of said negligence of defendant Slim and the aforementioned attack, plaintiff Omar Graham suffered bodily injury resulting in pain and suffering, disability, disfigurement, scarring, all other, parts of negligence that we mentioned before. So I'm not going to read all of that. They are demanding a judgment against him for damages in the excess of $50,000 and any other further relief that the court deems just and proper. So now we're at 250K. Then we have negligence against security of freehold. So pretty much the same thing in regards to the negligence against Slim Stunna is going to be for the other entities as well. So let's see. All right. So it says the premises was leased and the venue, Freehold Studios, was owned and operated by defendant Freehold. The party was hosted and the premises was subleased and possessed by defendant Slim Stunta. Defendant Freehold, as the lessee of the premises, negligently failed to adequately maintain the premises in a safe condition by failing to ensure sufficient security detail for the party and or by entrusting the premises to defendant Slim Stunta without taking reasonable measures to ensure the premises had sufficient security detail at all times when said premises would be open and accessible to invitees. So Slim hosted the party, right? He put together this party, he sent out the invitations. So we're going to sue the people who pretty much owns the building, right? And owns the building overall and owns the venue because yes, Slim should have ensured that there was adequate security there, but also it is the duty of the property owners to say make sure that you have, like, if you are holding events, make sure that you have proper security in the event something will happen. I'ma sue everybody, and that's normally what we do in these type of cases. We will sue everybody from the person who hosted the event to the owners of the venue. whatever the case may be, we're going to sue everybody. We worry about non-suiting them after we find out that they have absolutely nothing to do with the incident at hand. That's usually how it works. um Freehold knew and should have known that the attacks on the party attendees were possible, and or that the attacks on any guests or invitees on the premises were possible. They should have known that sufficient security detail was necessary to protect the party attendees from attacks and to prevent such attacks. Freehold had a duty to ensure the premises was provided adequate security by any and all of sublessees, lessees, and or possessors of the premises. Defendant Freehold was the legal and proximate cause of plaintiff Omar Graham's attack, which occurred without the assistance, rescue, or aid of security. Um, Proximate cause of all of these that he has suffered. In that case, he is also asking for a judgment against Freehold for damages in excess of $50,000. So we're up to what, 300K? So more than 300K. Negligence against Goldman. Let's see. So the premises was owned and operated by Goldman. The premises was leased, and the venue Freehold Studios was owned and operated by Freehold. We know that the party was hosted by Slim Stunta. The defendant Goldman, as the owner of the premises, negligently failed to adequately maintain the premises in a safe condition by failing to provide sufficient security detail for the party. Once again, they knew that they had a duty to take reasonable steps to ensure adequate security for the premises. They should have known that invitees and the public could be exposed to attacks without adequate security in place. So people will be like, well, how was they supposed to know? At the end of the day, you never know anything. If you see like these mass shootings where, people just run in these businesses, like we never think about it because it doesn't happen on a day-to-day basis, but uh every facility or building or premises, that's the right word I want to say, every premises should have an adequate amount of security in place, as well as insurance. You got to have insurance, business insurance. Let's see. Goldman had a duty to take reasonable steps to ensure was provided with adequate security. And they are two legally and proximate cause of his attacks because it occurred without assistance, rescue, or aid of security. So pretty much this man got jumped and there was no security there to help him. He is asking for $50,000. So we're at 350K right now. So that's it. So as of right now, he is asking for 350. Well, let me step back. He's asking for more than $350,000 plus other damages or whatever the court deems just and proper. Y'all been with me long enough to know with these type of cases that you have to produce records. Okay, you have to produce records. So medical records, medical bills, incident reports, photos, videos, anything that can show what happened and how you suffered. That is how this is going to work. If I am not mistaken, I believe that let me see. I'm gonna go back. I am going to go back right quick because what I saw on the docket, somebody did a request for production. I'm gonna share my screen one more time. All right, so hopefully you guys can see this. So this is defended because remember, Sony Ventures actually filed a notice of appearance in the answer. So what they have already done was submitted a request for production. Request for production is one party asking the other party to produce records. So here, when did they do this? It was filed October 22nd, and normally you have 30 days. Yep, you have 30 days to provide these documents. So by November 21st, they need to have this over to them. So this is Sony Ventures' first request for production to the plaintiff to produce the following documents. And I'm gonna get to um what they're asking for. Okay, so they're asking for all documents which reflect evidence or summarize all medical bills which have been incurred by plaintiff Omar Graham as a result of the alleged incident, including but not limited to doctor bills, hospital bills, laboratory fees, post care treatment, rehabilitative treatment, psychiatric treatment, or nursing care. This response should also include any letters of protection and all invoices for medical service rendered, which shall include the amount charged for the medical treatment rendered, whether insurance covered each treatment rendered, and the amount accepted by the medical provider for each treatment rendered. So you have to be in mind, if we go back to the complaint, he is saying that he was injured. He is suffering from mental anguish. All of those things you have to prove. And so Sony Ventures saying, okay, you are stating all of this. We need to see proof. All medical records, let's see, correspondence, prescription, pharmaceutical records, medical reports, all of those, medical x rays, physical therapy records, laboratory results, any communication between the plaintiff and the healthcare providers, any records from the doctor, the hospital, clinics, medical facilities. He mentioned that he had a loss of earning capacity. So what he got to produce, he has to produce true and correct copies of W-2s, 1099 forms if you are self-employed, and this is going back to 2014 to present. So yes, you have to produce those things like within a 10-year, that you can't do more than 10 years. So in 10 years you need to produce records showing that you have worked. All documents which reflect evidence or summarize the income summary currently being earned by the plaintiff. Let's see, social security, pensions, all of that. Current, it says current employment. All documents which constitute evidence or reflect any damages the plaintiff has suffered um, as a result of the incident at issue in this litigation for which the plaintiff are seeking compensation other than medical bills and lost wages. Um, let's see, social security, photographs, and this is all the typical things. So everything that you are claiming you suffered in your complaint, you have to produce. Plain and simple. So you have 30 days to get all this. Now, here's the stuff that we don't like. It says a copy of your birth certificate. As plaintiff paralegal, we ain't sending y'all no birth certificate. I'll send you a copy of their driver's license, but actually, what does this driver's license have to do with anything? So sometimes we don't even send that. Ha- To be honest, none of this right here, 16 through 21, we don't send. Now it says, now here's the thing, any and all emails, correspondence, social media posts, we got to see. Now, I always scrub our clients, the plaintiffs, I scrub their social media. And I really, really during the intake process, especially, it doesn't even matter if it's a car wreck, truck wreck, slip and fall. I don't care what it is. Did you post this on social media? If and I go on there, even if they say no, I go and I find them and I look through their history to see. And I do mention to them, regardless of you deleting your account, we could still subpoena, or they could still subpoena your social media and find out a lot of things. So you got to be mindful of that. But they want to know if you posted this. They want to know if you ever applied for Social Security, or if you ever applied for workers' comp, or if you ever apply for long-term disability. Copies of reports from investigators, documents that you contend your to contend support your position that this defendant had notice of the number of invitees. Let's see. Documents that you contend support your position that you were an invitee to the party held at this premises, and copies of the business card you presented to Tasha K. These people aren't playing, okay? So Sony said, okay, we're going to file this notice of appearance and we're going to get right into it. So hopefully, right now, Mr. Omar and his attorneys are gathering these medical records. They are going through everything. They are getting his social media, because it did say in the complaint that this was all over social media and the internet. Now, personally, I did a search. I didn't see anything, but I didn't honestly search that deep. So I am going to go back and do that. But here's another lawsuit against Tasha K. And it's crazy because I this is not the first instance where I've heard that Tasha K is attacking people. I don't know what that is about, but that's crazy. The amount of lawsuits that she has against her, especially one where you're owing millions of dollars, you would think that somebody would try to stay out of trouble so they won't be in more debt. But hey, who am I to judge? What do y'all guys think about this? Put that in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.